last matter we heard this morning is KNL Custom Homes versus Konstantinos.
Dotsikas.
Thank you.
It's a mouthful.
Yes, it is. How's the first name pronounced?
Konstantinos.
I
Konstantinos
was
Dotsikas.
putting an
Yes.
exclamation point. I apologize.
That's okay.
Okay.
I can't pronounce his wife's name at all.
Okay. And the appellant has waived oral argument, and you are here arguing on behalf of the appellee.
That is correct, Your Honor.
All right, let me get that case up. You'll have 15 minutes to argue, and we have read the case, and we're ready to go.
Thank you, Your Honor. I'll be brief. May it please the Court, my name is Mark Fusco. I represent the defendants appellees, Mr. and Mrs. Dotsikas. This is an appeal from the trial court's entry of summary judgment in favor of the appellees on the basis of res judicata. The trial court correctly entered judgment in favor of the appellees, and this court should affirm. By way of background, KNL Custom Homes sued the Dotsikases in 2011 for breach of contract and to seek the enforcement of a $27,000 mechanics lien. The Dotsikases filed a counterclaim for negligent construction. The case hung around for a while, discovery was done, but ultimately it was dismissed with prejudice in 2012. The dismissal with prejudice was not conditioned on any particular event, such as a written settlement agreement to be submitted to the court later. There was not an agreed judgment entry that would have given the trial court continuing jurisdiction in terms of enforcement. It was simply a dismissal with prejudice of all claims and counterclaims. The case was over. KNL refiled the case in 2014, seeking damages for breach of the same contract that had been dismissed in the 2011 matter. The dismissal of the previous action in 2011 was a complete adjudication of the case and a complete bar to the 2014 matter reinstituted by KNL. The 2011 and 2014 cases were both based on the construction contract between the parties. Both sought the recovery of the unpaid contract price of $27,000. The dismissal with prejudice of the 2011 case is a complete bar to the allegations raised in the 2014 case. The dismissal in 2011 was unconditional. It wasn't premised on a settlement agreement or subsequent entry. There was no agreed judgment entry submitted to the court to provide for continuing jurisdiction. The other claims raised the second time around in the 2014 case, the fraud claim in particular, was just an effort to try to get around res judicata and breach of contract claim. They were still seeking damages for $27,000 for breach of contract. In Ohio, it's long been the law, you can't intentionally breach a contract. You can't fraudulently breach a contract. A breach is a breach. And by trying to characterize it as some sort of fraud did not rescue their claim. It was still a breach of contract claim. That claim was dismissed with prejudice. Each party bore their own cost. The trial court correctly entered summary judgment in favor of Mr. and Mrs. Dotsikas.
So, factually, from reading the briefs, it sounded as if in the 2012 case, both parties were represented by counsel.
That is correct.
And both counsel signed off on the settlement dismissal.
That's correct.
So when the appellant says in its brief that this oral contract was entered into at Whitey's up in Richfield, and that neither of the attorneys was there, what's the sequence of that? Is that after the settlement has been drafted by counsel?
Well, that's part of the problem, Your Honor. Well, there was no formal settlement agreement drafted by counsel for either party. I believe sequentially the meeting at Whitey's took place before the dismissal entry. And then the parties inform their respective counsel the case is over. So the Dotsikas gave up their counterclaim for negligent construction. The KNL Custom Homes gave up its claim for breach of contract and for enforcement of the mechanics lien.
And so it just said basically this case is settled and dismissed with prejudice. It didn't go into any terms.
That's correct, Your Honor.
But at the time that the dismissal was filed, each party was represented by counsel.
Yes, Your Honor. And there is an affidavit from counsel for the Dotsikas family who represented them in the 2012 dismissal, referencing an email exchange with counsel for KNL in which they were discussing the dismissal of the case. And the only substantive thing in that email exchange, other than it was going to be dismissed with prejudice, each party to bear its own cost, was that the mechanics lien was going to be released of record.
Can you say that again?
The mechanics, in the email exchange, they agreed that the mechanics lien that was filed against the property was going to be released.
As part of the settlement.
That's the only term. If there are any terms to the settlement, that was the only term.
And then what happened with the mechanics lien between the time that the case was dismissed with prejudice and the time that the new lawsuit was filed?
The mechanics lien was never released by KNL, but because the mechanics lien was part of the 2012 case, by statute, revised code 1311, if a mechanics lien is subject to enforcement in a lawsuit, and the lawsuit is then dismissed with prejudice before full adjudication, the mechanics lien is void by operation of law.
And was that argument before the trial court when it granted summary judgment?
Yes, Your Honor.
Okay. And there are findings for relative to that mechanics lien by operation of law in the court below?
Well, the court didn't make any specific factual findings in granting summary judgment, but that was an argument that was presented to the court as a basis for granting summary judgment when that issue was raised by KNL.
Because it kind of has to me the flavor that argument about the extinguishment of the mechanics lien, because, wait, let me back up. The first lawsuit was not a foreclosure on the lien lawsuit, it was a breach of contract?
Well, it was rather inartfully pled. They were enforcing the mechanics lien. So the only way really to enforce a mechanics lien is through a foreclosure procedure. They didn't file, it didn't go to the magistrate's department for formal consideration for foreclosure, but it was a breach of contract for $27,000, which was the unpaid contract price, and an enforcement of the $27,000 mechanics lien, which is exactly what they claim was owed under the contract. And they filed both.
Okay, so, and then moving forward, we have a new defendant in the second lawsuit, right? We don't just have...
No, there's only one defendant. I'm sorry, go ahead.
Okay, we have some arguments relative to the closing, do we not?
We do, but that was on, after the summary judgment was filed and before the court ruled, KNL sought to amend their complaint and to bring in the title company and a new claim for civil conspiracy and a new claim for tortious interference with a business relationship. Because the claim was, at least as pled, but the court did not allow the amendment, is that there was some sort of conspiracy that the money should have been held. The money was held in escrow and then improperly paid out to the Dotsikas at closing rather than to KNL. That never happened. There was never any money in escrow. I mean, there was an allegation that there was money in escrow, but factually that never occurred because the underwriter was able to write through the mechanics lien because by statute it was no longer effective.
It was no longer what effective?
Effective. It was void once the case was dismissed.
So we don't have the situation, because the amended complaint was not allowed, we don't have the situation where any claims regarding the closing without payment on a lien were actually litigated in this case.
That's correct. The trial court denied the motion to amend, which I think was within its discretion to do so late in the game, and especially since there was really no merit to that claim based upon the language of 1311, that the mechanics lien was void once there was a dismissal with prejudice of the first claim.
Well, whether or not there's merit to the claim, that claim wasn't decided on the merits.
Correct. That's correct. And in reading the record, I believe there's counsel for the appellant appended a letter which was not considered by the court because the amended complaint was not considered by the court, but there is a letter from me to the title company explaining that situation when the mechanics lease was no longer of any force or effect. And that's why the deal closed, because there was no, I don't know where they got this idea that there was money in escrow. There was no money in escrow. And if the court has no further questions, I would just respectfully request that the judgment of the trial court be affirmed.
Thank you very much.
Thank you.
Thank you for your argument. We'll issue an opinion which will be sent to both sides, and you may check the Supreme Court website.
Thank you, Your Honor.